live. Welcome, welcome, welcome. Good morning, everyone. Thank you so much for joining us for another episode. I named our episodes a while ago and then we stopped having them. So I don't remember what the name is. But my name is Kendra Pearson, and I am the administrative assistant for Virgil Hawkins Florida Chapter National Bar Association Fellowship. And we are super excited to be here. We are going to be talking about debt and bankruptcy. We're going to be talking about consumer credit, what that is, what that means for you, your life, and how you can get the jump on things, be proactive about all of this prior to you really being on the other side and needing a lawyer and learning backwards. We're just trying to be proactive. As we always say, knowledge is power, but the application of that knowledge is even more powerful. Just having it in advance, knowing what needs to be done prior, contacting your attorneys prior to us getting into those oopsie situations. So anyway, we're going to start off by introducing our amazing panel. We have a return, we had to bring him back because he was so awesome. So Attorney Jay Mobley, can you introduce yourself?
Hi, everyone. I'm Jay Mobley. I'm an attorney with the Legal Aid Society of the Orange County Bar Association. I practice in consumer debt collections. I work with a little bit of bankruptcy stuff. I do student loan counseling and things like that, and a whole bunch of other stuff.
Awesome. Thank you, Jay, for returning and to educate our community. And Attorney Camila Jolly.
Yes, hi, I am Camila Jolly of Jolly Esquire, and the focus of my law firm is helping people achieve financial freedom, and we primarily do that through two different ways. One is debt relief, which is essentially bankruptcy, because most of the times that is the avenue that some people have to go through to get debt relief. And the other way that we assist with financial freedom is through entrepreneurship. So helping people get their businesses started, helping them with trademarks. It's such a weird combination of areas, but I love it and it works. So
yeah, it's a little bit of everything, like you said, but it's good. It keeps it interesting, right?
Yes.
It ever changing, for sure. So awesome. Thank you so much for joining us. I really appreciate it, for sure. And I just realized every time I say your last name, Jolly, I have to smile.
Yes.
It just makes you like, you got to, right?
Happy.
So,
yeah.
Say it and frown. That'd be odd. But yeah, so we're going to start off just with some of the bare basics. Like for me, I did not get a chance, I will admit, to look at what consumer credit or consumer law really means. So I was like, well, why would I look it up when I have two amazing attorneys to get that answer from?
It's one of those things you see and you hear, but you've never really dug into it. Consumer, if you define a consumer, it's somebody who buys stuff.
Yeah.
That's really as simple as that. I mean, you can be a business and be a consumer. You're consuming goods and turning it into other things and selling it. Or you can be a consumer in that everything you buy at the grocery store are consumable goods. So it just means you go out and you buy stuff. That's the fun part of what we're talking about.
That is fun.
So buying is always fun. Paying is not always fun.
It is not. I agree. Yeah, it's always fun to spin it up, and I'm a very good consumer, should I say? So yes, go ahead, Jay.
I'll just dive right in, and basically, yes. I think this will work well because I do a lot of debt collection defense, and that's kind of the first step into a bankruptcy, is if you get in trouble with debt collections. Now, the way it usually works is you're going along fine, you're using your credit, which is a good thing. You've got credit cards, you've got loans, you've got things like that. And as long as you're able to make the payments, everything's rocking along great. What happens is then if, especially recently, you lose a job due to COVID or something like that, or you have a financial setback, I see it a lot with retirees when it comes time to live on a smaller income. Things like that. So some bump in the road happens with your budget and you get behind on credit cards. You can't make your monthly bills. So you have to start making choices like, do I feed myself or do I pay my credit cards? And legal aid works with low-income clients who are on a pretty tight budget to begin with, even when they're working. So you get a snowball effect. You get behind on one, then you get behind on a couple of them, and before you know it, you're behind on all of your debts. So what does that mean? What happens? What can happen to you? Debt collection will start with phone calls and late notices. And eventually, if you're not able to take care of it, they do have the right to sue you for the debt. There's statute of limitations involved, meaning they have to sue you within a certain amount of time from when you stop making payments, but it can vary because your credit card may be incorporated in another state.
Wow.
So it gets really confusing. So I can't tell you, if you get past the 4-year mark, you're fine. That's not always the case, So
Right.
you have to look at each account individually. But let's assume that you've been sued by a credit card. What happens is you will be personally served by the sheriff or a process server, what is called a summons and a complaint. The complaint could either be a small claims action if it's less than $8,000, or it could be just a regular lawsuit in civil county court. Now, the difference being, if it's small claims, you're going to get a notice to appear. You're going to get a notice to appear date. That is not your court date. That's the date you show up and there's a mediation that takes place. Now, it used to be more of a mediation.
Right.
Hopefully we're getting back to that with the courts opening up. But lately it has been you, the judge, and the credit attorney for the credit card. And you either make a payment plan or you proceed with the case. That's kind of the only options you have.
Wow.
So if they sue you, they have the right to collect the balance, and that will usually include an interest rate that is kicked into a default interest rate, meaning that your balance is going to grow quicker. They get to sue you for their court cost and any attorney's fees that they have in collecting or pursuing collection of that debt. Now, a lot of folks don't understand why they add that on there, but 9 times out of 10, it is in the contract that they get to do that. You either click through it or you signed it. Even if it was online, it's that thing you never read that you click through. It says they get to do all that. And state law says they get to do it to a certain degree. So what does that mean? In Florida, they have to prove very little to get a judgment against you. It's very little because they're not suing you for breach of contract. You had a contract. I'm going to give you credit. You're going to pay me back. It's a contract, written or click through on the computer, whatever. They don't sue you for breach of contract because they have to prove a lot more in those type cases. What they do is serve you with an account stated cause of action. And that goes way back to the old general store days when you used to go and put that on my account, we'll settle up later. And the farmers used to do it in the fall when crops came in, they go settle their balance on their account. All they have to prove in Florida is that you had dealings with this company, the credit card company. They extended you credit. You used that credit. They mailed you at least one periodic statement with a balance, just one, and you didn't dispute that balance in writing within 60 days. So that's all they have to prove. So when I talk to folks, I'm like, barring them doing something wrong and pursuing the lawsuit, you're probably going to end up with a judgment.
Right. Because that means, I'm sorry, but that means like by the time I get in trouble, like and say, oh no, I can't pay this bill anymore, I'm past my time to say, no, I don't want this card or to do anything, because now it's 60 days is only 2 months and some people don't open the mail that often.
Even if you disputed that amount in writing, they would investigate it. But let's face it, they can track down everything that you've done on the card, unless it's really a case of ID theft, which is a whole other conversation. You use the card, it's your charge, it's your balance. So they're entitled to collect on that. So let's say the judge agrees and gives them the judgment. What does that mean? Well, a couple things start happening. First is they will send you a copy of the judgment in the mail, signed by the judge, and it will order you to fill out a fact information sheet. That is nothing more than a collection tool for the other side.
Yep.
You have to disclose, and this is Florida statutory law. So if you don't fill it out and send it to the creditor's attorney, you can be found in contempt of court. You can get a fine. That fine, if unpaid, is a court cost. It can suspend your driver's license. So you got to fill this out. So you fill it out, and it has things like, where do I bank? Am I married? Have I got kids? What do I own? Where are all my assets? Where are you coming to take something from me? And you have to lay it all out for them. Tax returns, pay stubs, things like that.
Yes.
So that is a collection tool that the state law says you have to do. In my practice, a lot of times I can avoid the judgment if we can reach some kind of settlement agreement. So that's the first thing you want to do. You want to contact an attorney or legal aid and say, can we avoid the judgment? Now, that means you're going to have to probably bring a little money to the table, but I'm going to get the best deal I can for you. And we may be able to set it up on reasonable payments, because they're probably going to be asking for astronomical amounts you can't afford. But once we get in front of the judge or at mediation, I'm going to beat a little reasonableness into the play. So I will give them your budget. You have to kind of be forthcoming and say that, look, this is what I got. And a lot of times we can get $25, $50 payment plans, maybe even get no interest on the payment plan, lock it into a set amount. You're making a principal payment and eventually you pay it off. We may knock some of the principal off to the point where it's not a bad deal for you and you avoid that judgment. Now, why would you want to avoid the judgment? Because if you don't, it's issued for 20 years at a time. It's going to sit there. It's going to draw interest. It is going to haunt you. And now they have teeth to collect. And by that, I mean they can garnish your paycheck up to 25% of your wages. They can freeze and take every penny in a bank account with your name on it. That's any bank account with your name on it.
It's Louise.
So there's teeth in a judgment and it's going to haunt you. The only way to get rid of the judgment is to enter into a payment plan on the judgment. So we could make a payment plan to avoid the judgment, or if you've got that judgment, we may be able to make a payment plan. And if they take a payment plan in writing and you're making that payment, they lose the ability to garnish your wages or a bank account. So there's protection in a payment plan. Now, the next step is the only way to get rid of that judgment, pay it off or bankruptcy. Depending on the size of that judgment, that's when we make the decision that someone actually may need a bankruptcy.
Wowzers, that's a lot. That's pretty intense to know that well, one, something I struggle with, like maybe I was in a bad way as younger and had this judgment that I couldn't pay, but then now I'm doing better and now they start getting garnishing the wages, affecting my current life, and then, if people get married or have children, now it's like impact on impact.
Yeah.
And
I have a lot of people that forget they had it. They got it when they 10 years ago. And the judgment may have been sold to another company, and all of a sudden they're right in your face saying, you got to fill out a new fact information sheet.
Wow.
We're going to hit you with a wage garnishment. We're going to collect.
Wow.
Yeah.
That's
there are some protections. Let's say you don't want to do the bankruptcy and you get a garnishment on your wages. There are protections, the best of which is a head of family exemption to garnishment. So if you pay more than half the support of a dependent is loosely defined. It's a moral or legal obligation to support somebody. So as long as you can prove that you're paying more than half of their support, the judge is most likely going to give you the head of family exemption. That prevents any amount from being taken from your wages. It'll cover the bank accounts too, if the wages are what's accumulated in the bank account. There are other protections like Social Security is protected, pension plans, there's other things, but it gets technical. And that's when you really need to meet with an attorney to see what all you could qualify for an exemption. The thing about that is confusing. A lot of times someone goes through the process, they get a judgment, there's a garnishment attempt, they get the head of family exemption, and they think, I've beat it, it's never going to come back. what they don't realize is that they get to attempt to garnish you. I don't know that there is a set rule. They just get to come back and keep trying. And you
Wow.
have to prove your exemption
Every
eligibility
time.
each
Every
time.
time. Yes.
So
Yikes.
it's going to come
Oh,
back.
goodness. Yes. And I'll share something with you. When I was younger, I had a judgment against me, right? From I'm telling you, kids, be careful who you're friends with, because a friend, had taken a car of mine while I was asleep, and they wrecked the car. But they wrecked it. They ran into a rental car company,
Oh,
and so they wanted the money, of course, for that car.
Sure.
And they took both of us to court. Of course, I'm the only one that showed up, so I accepted the full brunt of that judgment. But I was by myself. I didn't even think about getting an attorney. And it was just me and my daughter. So, I mean, thankfully, nobody garnished my wages, but I ended up going through a whole lot behind just not being properly prepared for that.
Sure.
And even to the point of getting my license suspended because I couldn't pay. At one point, I fell behind and they suspended my license, even though they say they wouldn't, because I'm like, the payment was sent. There was a misconception, and
Right.
the payment was late, but I had sent it, and yeah, it was very weird. And I don't even know until this day. And I don't know if you guys could tell me, because eventually I reached out to them and I was like, listen, I've been paying on this for a very long time. And I had income tax at the time. And I say, what can I pay because someone say, oh, maybe you should see if you can,
Lump sum settle it.
yeah, settle with them. You've been paying for a while. And at this point, it had been a couple of 2-3 years. And so the lady looked, that I was on the phone with, looked at my account and she said, I see you are the only one that have been making payments. So let me call you back. And they ended up taking payment from me, but they did not release the other young lady from the judgment. So I don't even know what is happening. Because of course we were no longer friends after you wrecked my car and caused me whoa. That's how friends do to each other. But like in that incident, like with me, and like I paid my part up, they wrote me a letter saying, okay, we release you.
But not the other party.
But not the other party.
Yeah.
And I wouldn't even know where she was to even,
You actually got lucky, I think, because they did not have to release you. They could have made you pay every dime of it.
Yes.
Wow.
So that's the thing. If you have joint credit with someone or you're on a car with someone and you both get sued, they don't care who pays it. They're coming after both of you. And I see all too often, especially in cases where there's a divorce involved or something like that, or you've been nice and given somebody a cosigner. You put yourself on the hook. I just see it all the time where the party you helped is gone. I mean, the most egregious case that I had seen, I think, was an elderly grandmother helped co-sign student loans for a granddaughter, who then got a job making $40,000 or $50,000 a year and said, I'm not paying my student loans. And they started taking it out of grandma's Social Security.
Oh my goodness.
Yes. So that is a little opportunity there to talk about student loans. That's a whole different matter. Student loans do not have to come through a local court. If they're federal student loans, they do what's called an administrative garnishment. It's basically a letter that says, oh, by the way, next paycheck, we're taking a bunch out. It's actually not as bad as the state garnishment. It's like 15% that they usually start with. But it's entirely non-court related. It's the Treasury sending a letter to your employer that says, you send us this amount of money. And your only recourse is to ask them for a hardship reduction. You can complete a financial affidavit for them and ask them to reduce the amount, but they don't have to. It's the federal government. They don't have to do that. So, yeah, if you got student loans, they're no joke because they can take it out of your Social Security. With a normal judgment, you go run up a credit card, they can't take that out of Social Security. But if it's a federal student loan And private loans that are treated as student loans
Mhm.
also have the same issue.
Yes.
Oh, wow.
And can't get rid of those in bankruptcy. 99 times out of 100, you're not going to get rid of them in bankruptcy.
Wow.
So they will follow you forever. So if you got student loans, they're no joke.
Well, speaking of student loans, there's been so much going on, like in the media, about potentially, well, getting forgiven some, there's so much out there right now. So what do you guys know that's out there that may be somewhat true? Because I've heard that certain loans can be forgiven, certain loans, but certain ones, but that's just it, just certain. They
There
don't
are
say.
a couple of programs that have been around for a while. Public service loan forgiveness is one of them. It's 10 years working somewhere like legal aid and 10 years of payments. It's usually a nonprofit that you have to work for.
Okay.
The public service loan forgiveness is still there. That's a good one. There's one for teachers, I think, and maybe for nurses, but they're individual programs and they've been around for a while. The new stuff we're talking about, forgiveness and everything, I'm not betting on any of that because it has to come through Congress.
Right.
Yes.
Yeah. So don't count on some relief in the next year because
Anytime soon. Okay. So it's like keep paying your bills and don't. But let me ask you, Camilla. I also heard that what now? I don't know how true it is, so you can tell me because you're the expert. That when it comes to student loans as well, and you may know JS also, that with bankruptcy, they're starting to consider some student loans in that regard as well. Do you know anything about that?
So there's been discussions about it. Student loans, you can bankrupt them, but it's a very, 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 very difficult process to actually get it done. So
9 times out of 10, the people I think that would qualify for that could probably get the total disability discharge that's available
to them. Yes.
So it's the standard that is really high.
It's really, really high. So I think they are considering it, but it's still, again, it has to go through Congress because a lot of people don't know student loans. It used to be something that you could include in a bankruptcy, and they changed the law, I believe, in 2004. So yes, so it's something that they may be considering. Again, I believe that they are, but who knows how long that's going to take for them to actually do all the necessary paperwork and go through all of the politics and get it done. So
okay, so right now it's just the buzz. It's not for people to sit here and plan on it. So you heard it here, folks. First, I don't know about first, but you heard it here. Don't sit and believe that that your dreams, your wildest dreams, have come true, and that your debt is going to miraculously disappear. That your student loans will just wash away, whether it's bankruptcy or, you like even with Jay said, there's programs out there, but I caught the part where you said like even with the nonprofit, it was like 10 years of work and 10 years of payment, right?
Right.
So you have to pay and work. So it's not even like, oh, I worked here for 10 years.
No, you've got to earn it.
But you have also been making your current payments because please believe me, you guys, I was sitting there trying to rack up how many years I had to go.
Yeah. Talking about your payments, one of the things folks need to always look for is that payment-based income, or income-based repayment, I think is the term they use.
Right.
It means that they base the amount you have to pay every month off what you're making. There are several different programs, and what you can do is you can go online with your servicer, you can apply for an income-based repayment program, give them your financial info, and you can actually tell them, I want you to give me the program that means the least payment for me right now. Right. So they'll figure out which one's best and gives you the lowest payment. But look at that. Everybody should be on an income-based repayment program. And those are, in general, if you make payments for 20 years under an approved program, then you can ask for the balance to be forgiven. So
Okay.
that's, now, one of the things that people don't realize, the borrowers don't realize, is that if you default on a federal student loan, and they have to send it to their collector, there are huge fees that get added on. And when I say huge, I'm talking a percentage of your loans. And I can't remember, but I think I've seen it, 20% or so. It's ridiculous. Whatever it is, it's like, could be thousands of dollars simply for transferring it into collections.
Yes.
And that is 100% collectible. It adds to your loan, and then they charge interest on it.
Yes.
So it could be a never-ending story if you're not careful with your defaulting on your student loans. So it's even more important to kind of stay out of debt, even though by the time a lot of us figure that out, we're in it.
The minute you're in it, go to them and ask for, if you lose your job, ask for a deferment and apply for that income-based repayment. And, you got to talk to them. You got to say, look, I'm experiencing this financial hardship.
Right.
I need an income-based repayment plan, or I need a deferment because I lost my job. Most of them will work with you, but do everything you can to keep that loan from being in a default status.
Right.
So
just don't ignore it, because that's what people tend to do. They like, if I ignore it long enough, I'm gonna throw this rug over it and walk around it. It's not there, and that's not true.
That goes with any debt. Don't ignore it.
Yeah,
don't ignore
always
it.
Deal with it.
And that's the thing. Most people don't want to face it, and I know I've had that issue. And it's like you kind of have to, like they say, bite the bullet. You have to just take it on, just face it, because sometimes it could be worse than you thought, but sometimes it's not as bad as you may think. Now, but you did say something like with deferment, and we know that during this pandemic, the government had placed like a halt on like all student loan payments needing to be paid. Now, what's the update in regards to that? Inquiring minds certainly want to know, because I'm one of them inquiring minds.
I think it's through September, and I haven't heard anything about it being extended.
I don't think they're going to extend it any further. I'd be very surprised if they did. Because I believe for student loans, it's September. I believe evictions, it's like September. I believe
June. It's the end of this month for
evictions. Oh, it's June. Oh.
So June 30th, that's another, I know this isn't housing, but that's June 30th, the CDC order expires unless there's some extension. If you've had an eviction case that you've lost on paper and they're just withholding that writ of possession, they're going to start moving after June 30th.
Yes. Wow.
No, and I'm glad you mentioned that, Jay, because that's a great time to plug the fact that we, Legal Aid and Virgil Hawkins, we are going to be bringing a housing panel to you on June 26th. Definitely be there. We ain't going to say be there, be square, just be there. Just really, if you really, because we need this information, we need these updates so that we can move forward and make educated decisions.
And if you've got a problem that can't wait for that information, call Legal Aid. We've got housing attorneys on standby because we expect a big increase in housing demand. So go ahead and call us now if you're one of the folks that's affected.
Yeah, I think the last time we had a panel with you guys were up like 100 plus, like 110% or something. You were very surplus in preparation to be able to assist our community, which I thought was awesome. That you're preparing to be in place for when this happens, which is what we're trying to do with panels like this, is preparing our community to be proactive prior to things taking place. If you know that you're in a situation, whether it's debt, whether you have questions in bankruptcy, we're going to put all this information into our chat, into the comments, because we are doing Facebook Live. So whoever's joined us or will join us on Facebook Live, thank you. We really appreciate it. And we look forward to hearing from you. And you can still put in comments or questions that you may have. I am monitoring that as well for these attorneys. Take advantage of the information that we're giving you today. And like I said, I'm going to place both of their information, all of our information. You can reach out to us. Now, I know time is drawing out, but let me ask you, Camila, what news do you have on the bankruptcy front? Because a lot of people are facing these decisions, right? They have to make these decisions in regards to how they're going to move forward after going through the year that we experienced with COVID.
So the first thing is bankruptcy is not for everyone. And that has to be made very clear to people, because if there is a way for a person to get a debt settlement and work it out in such a way where they don't have bankruptcy on their record, that's usually my preference for the client.
Okay.
Because if you're not prepared for a bankruptcy and you just kind of rush into it and you aren't aware of what the ramifications are going to be, it can be a little halting in the beginning. Once you get out of the bankruptcy, you have this fresh start and it's like, okay, I can't really do anything. You're literally starting your credit and everything back from zero. So there's also the preparation part of it that needs to take place. If you are thinking about a bankruptcy and you already have a place, you know that your lease is coming to an end, you either need to renew or find somewhere else to live, so that you don't have to worry about having a bankruptcy and then having to get your credit pulled and them seeing that you have a bankruptcy and saying, no, we can't rent to you, or, going through all of those kind of things. So,
right. Yeah, I didn't know that there was, I've heard that, people are like, oh, just file for bankruptcy, and they make it seem like it's so easy and like a quick fix. But I've also recently heard that filing for bankruptcy or going through that process isn't quick, right?
No, there's two different types of bankruptcies. There's a Chapter 7 and a Chapter 13.
Okay.
So it depends essentially on how much debt you have, how many people are in your household, as well as what your goals are. So for people who are behind on their mortgage payments, a Chapter 7 isn't a good option for them. They need to file a Chapter 13 so they can restructure or reorganize and come out and make payment arrangements for any missed payments that they have. And Chapter 13s, you have an opportunity to do a mortgage modification through the courts. Okay. So for a lot of people who have mortgage issues, Chapter 13s are typically the best option for them. For people who are behind on their vehicle payments, I typically also don't recommend a Chapter 7. Usually with Chapter 7s, the property that you have, you're basically saying, I want to keep it or I want to get rid of it. It's one or the other. It's very difficult, and I don't want to say impossible, but extremely unlikely to kind of work out something where you can get caught up with payments, because that's not what a Chapter 7 is for. Chapter 7 is basically to keep or get rid of, and a Chapter 13 is to kind of catch up, reorganize, and restructure payments. So that's when you look at it that way, that helps to make it easier. But the process is very different. For a Chapter 7, it's about 6 or 7 months in the bankruptcy. For a Chapter 13, that's 3 to 5 years. So it's a very big difference in what happens, right? So for most people who get a garnishment and they are not able to claim a head of household exemption, more than likely, usually they end up in the Chapter 7, depending on, a lot of other things, but most people end up in a Chapter 7 because for them, they just need to get rid of the debt. They need to get rid of the judgment so they can literally move on and move forward with their lives. So that's
rebuild that credit.
Yeah, and they can start to rebuild their credit. There are some things that you can do to help rebuild your credit. Besides getting a secured card, there's different. You can get a secured card if you have a good relationship with your landlord. You can have your landlord's report to the credit bureau so it can establish that you have, or it can help to establish your credit. There are some apps and loan programs, or essentially what they do is you're borrowing money from them, but they're taking the money and putting it in a savings account for you. So that can also help you reestablish your credit after a bankruptcy. But it's something that is an option for a lot of people, especially if they have a lot of debt They have garnishments. They have just car repossessions. They have evictions on their record. Like those are the kinds of things that bankruptcy can help clear off and help people to have a fresh start.
Yeah.
Okay.
A lot of my clients come to me, and bankruptcy is not, you don't get to keep everything you own in bankruptcy.
Right.
When you come and you say, I want total forgiveness, I want a Chapter 7, I just want a clean start, I got all this other stuff hanging over my head.
Right.
You have to realize your homestead will be protected.
Right.
But if you have 2 vehicles and there's equity in one of the vehicles, there's a good chance that's going to be sold by the bankruptcy court.
Right.
So it's not a, hey, I want a bankruptcy. There's hoops you got to jump through. And if you own 2 pieces of land, one's your homestead, and you inherited a plot or a lot of land somewhere, an acre from grandma when she passed or something, you're going to sell that acre of land because it's a homestead, it's an asset.
Right.
So it's not like you said, it can be a jarring process when people realize you have to come to court and say, look, here's everything I own.
Right.
I can't afford to pay it. Here's my income. I got these assets. Can I keep some of them? And you just get rid of the debt. So it is a process. So I try to avoid that for my clients, but a lot of times it's just the only option.
Well, I do have a question in regards to that. Now, just because I've always been curious with, like, at what point or at what amount of debt, maybe should I say, would you advise somebody to consider bankruptcy? Like, I mean, like, where would you say, okay, you've accumulated this much debt, or you're this much under, maybe this is an option for you?
For me, it's going to sound such a lawyer answer, but it depends. And it really depends on that person's financial situation. Because someone who only has, who's on fixed income, and they literally like only get paid, maybe like $1,000 or $1,500 or something a month, and they have a debt or a judgment against them for like $5,000, it may not seem like a lot of money, but for their financial situation,
right,
that might be appropriate. For someone else, it may not make sense to do it. So it's literally like a case-by-case basis, because we have to look at the entire financial picture.
Yeah,
Gotcha.
I see a lot of clients, especially elderly clients, where you've got aggressive debt collectors out there that are just causing them stress day in and day out. They're on that fixed income of Social Security. It's never going to change, and yet it's protected. So I could, on the one hand, say, don't worry about it, they can't take your money. But if they've got that judgment, there's fact information sheets to fill out. There's garnishment attempts anyway, regardless. So it becomes, what's the best for this client? And it's not always a financial decision, and it's not a dollar amount. It's what is the outcome for this client, and will it benefit them and give them peace of mind? And that factor as well.
Yeah. Well, that makes sense, because as you mentioned, there's so many factors that play into someone's income there, so it's not just a debt thing. It's, okay, what's your current income? What's your living, your quality of life right now? Like, cause so some of that plays a part, which brings it full circle as to why you need to be willing and not afraid to consult an attorney, to make an appointment with legal aid, or to speak to an attorney like Camilla, and just to know what your options are, just to see. Sometimes you just need to know where you stand. And a lot of people are afraid of that, right? We're afraid of the unknown. Whether the unknown is good, you might be pleasantly surprised, or you might be destroyed. But no, not destroyed. Yeah. But you're never devastated, but at least you know.
Right. In this case, knowledge is power.
It is.
I mean, whether you get to use that power or you got enough power to make a difference is a different story. But don't shy away from knowing about the problem. That's what I see most people do. I would say 75% of debt collections lawsuits are won by default because people just are either too embarrassed or can't face showing up in court to tell the judge their side of the story.
Right.
Doesn't mean you're not going to get the judgment if you show up. but you'll know about the
Right.
judgment, you'll know the amount, you'll know who you got to deal with to get it taken care of. So it may not change the outcome, but you'll know. You're not going to get hit
Right.
6 months later with a wage garnishment and go, oh my God, where'd this come from? You're going to
Right.
know that's a possibility. And if you come talk to somebody at legal aid, that's going to be all explained for you. And you know your situation then. So don't get caught
Yeah.
unaware with a wage garnishment. And while we're talking about garnishments, there's a very important thing, a time that you need to know.
Okay.
You cannot wait and ask for an exemption later. You have to do it within 20 days
Right.
of
Yeah.
finding out. And that is
Whoa.
a hard deadline that's already went up on appeal.
Whoa.
Zivitz v. Zivitz is the case that's often cited on that. And of course, it was a divorce case that ended up in a judgment for one spouse, and they fought over assets and all that. But the appeals court says 20 days means 20 days. So if you get a wage garnishment, the first call you should make is to an attorney or to legal aid, or
Yes.
do what it says in the packet that you get and fill out a claim of exemption. Check every one you think you're eligible for. Let the court figure out which ones you're eligible for.
Right.
But just return a document.
Yes.
Now let me ask you this: when you say 20 days, that's 20
Calendar.
Calendar.
days. So
Yes.
you guys are out there in Facebook land and soon to be Zoom land, and and YouTube land. That's 20 real days. So it's like you don't have time to wait. It's not the old business days that stretch out because they're the business. They don't include weekends. This includes weekends. This includes holidays. It includes everything. And that's so important. Like I said, people, we put things off, especially things that are unpleasant. We don't want to deal with the unpleasant things in life. And unfortunately, like you said, Jay, to have this knowledge, I can prepare, even if it's something that's not good. You see the little meme would say, "Oh, doc, tell me the news," or whatever. Is it good news or bad news? It's like it's news. And that's the end of at the end of the day, that's what it is. It's news, and it's news that you can use, right? You can use it to say, okay, it's not as, like I said, it's not as bad as I thought. I can work with this. Or hey, guess what? That garnishment is going to be coming down soon. I need to prepare, or I need to see if I can prevent it. And these are the things that your attorney and consulting with an attorney can help you to understand, because we started this segment today with me asking, what is consumer law? Because I didn't know it. I knew more than I thought, right? Because I'm a consumer.
But it's always good to have it verified. You know what you're talking about.
It's good to have it verified and to know exactly what you're dealing with. It's not about making assumptions here. It's about us giving some real hard facts, and for you having that information that is so imperative for you to have. So we are in the process of wrapping up. I am going to give my amazing attorneys some final words. Just what would you like to leave with our aside from your information, which I'm gonna share once again, you guys, in the comments section, definitely utilize that. Okay, don't let it sit stale, and utilize it so you can get just this help in advance. Don't wait. So we'll start with Jay. What are your final words?
Time matters when it comes to dealing with these things. Just like there's 20 days to respond to a garnishment. When you get sued for debt, there's 20 days to answer that. Or you get that notice to appear date. So if you got 20 days to file a piece of paper with the court, don't call me on the evening of the 19th day. Call me ahead of time. Right. Because if you call me with 1 or 2 days left, I'm going to send you a blank answer form and say, do the best you can, come see me next week and we'll deal with the fallout. But you must file that written answer or you will automatically lose the case. There is no arguing after you default. I mean, maybe, but don't do that. Don't put yourself in a situation to lose just because you didn't show up. So call me as soon as you get it, or call somebody, or go file some kind of answer. May not change the outcome, but at least it will buy you time. It means that it has to go through court then. If you don't file an answer, you shortcut the process.
Wow.
If you file an answer, you've bought yourself time to talk to an attorney, talk to somebody about bankruptcy, you know, you bought yourself time. So time matters. Don't avoid it. Deal with it. And there may be more relief out there than you think.
That's good. Yeah, that was good. And Camila?
Everyone's situation is different. Oftentimes I'll have clients come to me and they'll say, oh, my cousin did this or my cousin did that. And I'm like, that doesn't apply to you. That's wonderful,
Right.
but that doesn't apply to you. Like everyone's situation is different. So I encourage you to go speak with an attorney to find out what your options are for your situation. Because what worked for cousin Bob or cousin Jane may not work for you, and likely won't work for you because they have things that they likely didn't tell you that's going on, but you can discuss that information with an attorney and find out what your options are so you can make a plan and to move forward.
That's great. And that's true. You know, it's not a one-stop shop. It's not a one size fit all when it comes to law. There's so many different factors, as we mentioned prior, and we'll mention it again, because guess what? We need you to understand that there's so many factors. You know, you're not the same as anyone else. We're all unique. We have unique needs. We have unique debt.
Yes.
But we do have one thing that we can have in common, and that one thing that we can have in common is getting help. You know, that's something that's available to everybody, no matter what your issue is, no matter how much debt, how little debt, no matter where you are on the bankruptcy spectrum. You know, knowledge is power. I said it, Jay said it, Camila said it. The application of that knowledge is what makes it more powerful. That is the key. Being proactive. Don't wait for your time to run out. Don't wait till was it 19 days and 23 hours, and then you want to reach out. And then you're gonna be like, help, please, don't do that. When you have, you know, start with day one and know what you're dealing with, and so you can have a plan of action and at least prepare yourself for what is to come. You're going in informed, you're going in being able to think things through, and instead of scrambling to find answers, you know what you're working with, really. So we are so glad that whoever is attending now, thank you for watching with us, becoming more educated with us. Those that will watch this as a replay, definitely share. We always willing to share the not so great information, but sharing the good stuff that will really help someone else. And you may not be in this position, but someone else may be. Mm-hmm. Help them. Share this information. We have some amazing attorneys that took time out of their day to share this information with you because they believe in educating their community. They want you to be better, and they want you to get help earlier. Yes. And it's not because it makes their job easier. It does.
It does.
But it's about you being proactive, so it'll make it easier also on you. So it makes the process a whole lot more just easier. It may not be, like Jay said, the turnout may still be the same, but your preparation of mind, and it just, you can't stop that. You can't beat that, right? So thank you, both attorneys. I really appreciate you so much. We're going, like I said, we're going to put your information out there and share it. So if you blow up, sorry, but you said you would help. So, but thank you guys for attending. You have a great day.
Thank you.